Hi, thanks for using my court coach. I'm Sarah and I'll be your instructor today as we discuss the Child Custody and Visitation Order Attachment, also known as the Form FL-341. If you are filling out this form, more than likely it is to attach to a formal order of the court, either a findings and order after hearing stemming from a hearing where the court made some temporary orders, a judgment. If you guys have either reached an agreement, you can use this form and fill out the details of the custody arrangement and attach it to your judgment. Or if you had a trial and the court made orders, you can use this form to fill out and attach to that. Or a stipulation and order for custody and or visitation of the children. Again, if you guys have reached an agreement that is a temporary agreement, you can fill out this form and attach to that. One of the reasons or the benefits to using this form, because you don't have to, you can just write out all the orders that you want to be included. But this form does streamline a lot of the required language, and it just helps make sure that you have dotted every I and crossed every T. For instance, this form puts into the order that the court has jurisdiction to make child custody orders in this case. Under the Uniform Child Custody Jurisdiction and Enforcement Act, it includes that each party had notice and an opportunity to be heard. It includes the country of habitual residence of the children, which almost always is going to be United States. And it includes the notice that penalties for violating this order can subject a party to civil or criminal penalties or both. This is language that has to be included in every child custody order that the court makes. So by using this form, you are assuring that that language is in there. You then want to go down below and mark the child custody box and list each child's name, birth date, and who is being awarded legal custody, who is being awarded physical custody. If one party is awarded legal custody, then you would just list that party's name. More than likely, and in most cases, it's going to be joint, so you can just put joint or you can list both parties' name. Physical custody, you would list the party whose name is being awarded primary physical custody to. And again, if it's joint, you can just write joint or include both parties' names. If the court has made a finding that there is a risk of abduction, you would mark box number 6. Box number 7, if the court makes orders regarding visitation, and usually they do, then you would mark this box. And there's a couple different ways of describing what that visitation is. If they do not specify how visitation is to be shared specifically, then you would just mark reasonable right of visitation to the party without physical custody. Oftentimes, a custody or visitation order stems or follows a family court services mediation appointment, where you and the other party meet with the mediator and see if you can come up with an agreement, and if not, the mediator makes a recommendation. If that is what is being ordered, then you can mark the box that says see the attached blank page document and just fill in the number of pages. Similarly, if you are choosing to handwrite out just the visitation schedule and there's a number of pages you're attaching to this document, then you would again just mark the box that says see the attached page document and write in the number of pages. If the court has not yet made visitation orders but has set a mediation date for you, then you would mark 7C and list the date, time, and location of the mediation appointment. If the court is ordering no visitation to a parent, then mark no visitation. If you don't want to either attach a document or describe for the court in your own words what the visitation is, and you want to just fill in the blanks, then 7E gives you the option of doing that. You would mark visitation and then identify which party is being awarded the visitation. And then there's a couple different options. If weekends are ordered, then you would mark the box that best describes how that visitation is to be shared, which weekends that the visitation would be exercised on, what day of the week it starts from, times, if applicable. A lot of times courts make orders that are to start from the end of school, so you could also mark that box if the court makes that order. There's just all sorts of options here, and hopefully one aligns with what the court ordered in your particular case. This is if the court makes orders specifying certain weekends. If the court just orders alternating week, and then you would mark box 7E2. and you would indicate the start date. That helps us identify which weekends to alternate. And again, list the times and days of the week that is supposed to take place on. If there is a midweek visitation, maybe a dinner one night a week, something like that, then you would mark the box at 7E3, list the date that's supposed to start on, and identify specifically what day of the week the visitation is supposed to take place on and from what time to what time. If there's any other visitation schedule that doesn't fall into any of these options, you can always describe it below, or as we stated before, you can attach that description of what the visitation is supposed to be to this form. If a party is ordered to have supervised visits, in other words, another person has to be present monitoring those visits, then you would mark box 8 and identify the duration. It's either going to be until further order of the court or other, if there's a specific date it's to be supervised till, and then identify the party that is having their visits supervised. And then there's an additional form that would need to be filled out as well. That's form FL-341A. If the court makes orders regarding transportation for visitation, in other words, either one party is responsible for the transportation or there's an exchange location, then you would mark the appropriate box here. You can see that there's an option for transportation to begin visits. Sometimes the courts make orders that the party who has the visit is the one responsible for transportation. 9C describes transportation from the visits. Sometimes it's receiving party, the party that's getting the child back at the end of the visit that they order to provide the transportation. Or sometimes, as I stated before, they select an exchange location, and you would identify those in 9D and 9E. If the courts make an order for curbside exchanges, that's 9F. If there's any other order made regarding how exchanges are to be done that is not specifically identified above, you can mark 9G and describe that here. If the court makes orders specifically pertaining to travel with the children, that is where you would mark in box 10. Sometimes the court will restrict where you can travel with the children to, or where you need to get permission from the other parent in order to travel. So if it's state of California, if that's the restriction, you mark box 10A. If it's certain counties, sometimes a court will identify that any travel outside of the county in which you live in requires written permission from the other parent, then you would identify that in 10B. If there's any other sort of restrictions that the court gives, then you would mark that in 10C. There is a form for holiday schedules that you would probably want to use if the holiday schedule is very intricate. If it's simple and there's only 1 or 2 holidays that the court makes orders from, you can describe that in box 11. If there's any other custody provisions, you can either use the form FL-341D and mark the appropriate provisions that were ordered in your case, or again, if it's not very much additional provisions that the court ordered, you can just include it in box 12. And if a court makes an order for joint legal custody, that's usually a pretty standard definition, but if there's anything more intricate than that, you're welcome to use the form FL-341E and attach it to this. Otherwise, you can just describe what the orders regarding joint legal custody that were made below. It is always the court's order that both parties, regardless of whether you're the custodial or the non-custodial parent, should have the right to access records and information pertaining to the minor children. So that is already filled in for you on 14. And then line 15 is our catch-all. If there's any other orders that were made that don't fit into any of these other categories, then you can always just check this box and describe it below. This form, like I said, will be attached to your order, whether that's a judgment or an order after hearing or a stipulation. I hope you found this helpful. Good luck.